In this video, I'd like to talk a little bit about the difference between the civil courts, of which the family court is part of the civil court. A civil court is where a civilian is against another civilian, as opposed to the criminal courts, where it's the Crown or a government agency such as the police prosecuting, or it might be a government agency like the Fisheries Act for somebody fishing in protected waters against a civilian. So the differences between the two are, in the civil courts, the burden of proof is on the balance of probabilities. It might sound like Chinese to you at the moment, but in the criminal courts, the standard of proof is really high. It's beyond reasonable doubt. So if you're not sure whether somebody committed an offence or not, you've got to give them the benefit of the doubt. Whereas the civil and family courts, it's the balance of probability. If you can imagine a seesaw or scales, weighing scales, it's more likely 51% or more that they did it or didn't do it, then that's the balance of probability. I hope this is making sense. Having said about the criminal courts and the standard of proof having to be beyond reasonable doubt, there's an exception to that, as there are exceptions to everything. And one of those is what's called strict liability offences, where you have to prove your innocence, such as careless driving, which is a non-imprisonable offence. And I first came across that when I was young and not very experienced at driving, and I was charged with careless driving. And I remember talking to the duty solicitor at the time. I think I was 18 years old at the time, and I hit a pothole on the road and spun off and wrote my car off. And she told me that I had to prove that there was a pothole there. And so anyway, I just pleaded guilty because I wasn't going to travel all the way back up. I was living in Rotorua at the time, up to Papakura, stay in a hotel, and somehow try and figure out at 18 years old how to prove there was a pothole in the road which caused my car to spin out of control. And I was still paying the car off, even though it was written off. So I paid a $350 fine. And that was it, but I still got a conviction for careless driving. It's not an imprisonable offence, and I wasn't disqualified from driving either, thank goodness for that. So there's strict liability offences where you have to prove that you are innocent. But the other ones, all the other criminal offences, the police or the Crown, the police do all but the most serious offences. So the really serious ones like murder are dealt with by Crown prosecutors. Those are lawyers, Crown prosecutors. And they have to, the police or Crown prosecutor have to prove every single element of the offence beyond reasonable doubt. Then there's some criminal offences. There's electable offences, such as a male assault female charge or common assault charge, where you can choose to elect trial by judge alone. We call them JATs, judge alone trials, or a jury trial. And then there are more serious offences which you can't elect, it's automatically a jury trial, such as what are called purely indictable matters. And some are only heard in the High Court, such as murder. With the jury trials, it used to be, and I'm concerned about our rights being whittled away, every single member of the jury had to find you guilty. But now they've changed them to lowered it down so that they've got majority juries now, and that's why you can end up with a hung jury. Civil courts, let's talk about the family court. So in the family court, it's more likely or not on the balance of probabilities. So I have found in my experience that if I can catch somebody out lying, If I can find and the judge finds that, if I can catch them out, then as a strategic plan, I'm quite strategic what I put in affidavits to try and catch them out, because if the judge finds that they're lying about one thing, they'll think they're lying about everything, and we're like basically hit a home run already with the case. But it's about how you go about doing that and the strategy used. In the family courts, the primary evidence is based upon affidavits that you file in court, which is a sworn statement, basically a story about what happened, and you can attach evidence to that. You have to reveal all your cards, lay all your cards out on the table, whereas the criminal courts, as a defence lawyer, you don't have to lay any cards out on the table. The other side do, the police do, the Crown prosecution have to give you all of the evidence that they have against your client, all of the disclosure, whereas you don't. Sometimes criminal defence lawyers can concede some points, such as saying that identity is not an issue. But other than that, the Crown or police have to prove every single element of an offence. In the civil or family courts, I'm really not sure about what happens in the civil courts other than family. You have to give the other lawyers copies of all of the evidence that you have to give them copies of everything. Emails you send, memorandums you send in the court, affidavits, everything that goes into the court, you have to send the other lawyers copies of it, so they have all the information. I think the reason for that is so that they can try and encourage everybody to know what's happening, so that you can try and reach an out-of-court settlement once you know where everybody is at. But it's very different from the criminal courts. We can have quite often in the criminal courts out-of-court settlements, more like negotiation with the police. We do have those as well. It's where we have meetings with the police to see if we can cut deals. Tell the police, if you pull this charge, we'll plead guilty to the other charge or something like that. And then it's only what goes to a hearing is what's essential to go to a hearing. If we can settle out of court beforehand, we do so. You might want, if you're in the criminal courts, you might seek a sentencing indication from the judge, which is where you ask the judge what sentence is likely to be imposed if the client was to plead guilty. And of course you'd file submissions as to what your recommended tariff for that particular offence and offending ought to be. And then if the client wishes to take it, they can take it. Otherwise it'll just carry on down the not guilty pathway. One important thing that I've been asked is, are the family court proceedings in private? Yes, they are. They're very much so in private. The criminal courts are open to everybody. A whole audience can sit in the back. They've got the press, the media all writing things down. It's full of people. Whereas the family court, it's the parties and the lawyers only. Sometimes if you want to have a support person or another family member, such a grandparent, in the courtroom, you have to ask the other party if they would consent or agree to that. And when you all go in the courtroom, the judge will want to know who else is sitting in the courtroom as well as the parties. So other than that, it's very, very private in the family courts. All the publications, they don't use the parties' names when they publish decisions. They use the first letter of the surname, like C versus A. So it is private.